Good morning, everyone. First, I want to say thank you to Professor Ifill for giving us the opportunity to share about our research. We are in awe of the example that you set for civil rights leaders and scholars and attorneys. This semester, my classmates and I had the tremendous privilege of conducting legal research for Professor Ifill and Professor Charles of Harvard Law. Specifically, for their amicus brief. Sorry, I got lost for a second. Specifically for their amicus brief in support of the respondents in the recently argued Trump v. Barber case. Our group was split into two parts: legislative history of the Civil Rights Act of 1866 and international comparative research, which my classmate will talk about in a moment. The Civil Rights Act of 1866 was Congress's first attempt at legislating birthright citizenship. The purpose of this research was to find out whether the framers of the Civil Rights Act, and eventually the 14th Amendment, intended to extend birthright citizenship to all individuals born in the United States. The answer was generally yes, with very limited exceptions for the children of foreign ministers and, at that time, Native Americans not taxed. An example of what we found when conducting this research was a conversation between Senator Cowan of Pennsylvania and Senator Trumbull of Illinois, senators in the 39th Congress. Senator Cowan asked whether the current language would extend to other foreign groups residing in the United States. Senator Trumbull affirmed that yes, it would. After a back and forth between whether this would extend to the children of Chinese immigrants or the children of German immigrants and whether there were differences between the groups, Senator Trumbull argued that the law makes no such distinction between these groups. These conversations were had, these concepts were thought of, and in a time when an argument was introduced to redefine the meaning of birthright citizenship based on a false idea of the framers' intent, it is critical that we maintain access to these historical documents. Legislative history is not only a tool for judicial decision-making and legal scholarship. It is an archive of the thoughts and debates of the framers and a time capsule of the evolution of legislation, kind of like C-SPAN from the 1800s. And if you were wondering, congressmen back then were just as sassy as they are now. I'll turn it over to my colleague, Naquan Bush.
Good morning. Okay, let's jump right in. So section 3C of the brief uses comparative examples to show why the framers were prudent to place birthright citizenship beyond political manipulation. The big picture is that when citizenship is no longer grounded or guaranteed by birth or the soil, countries often move towards systems based on ancestry, documentation, or ethnicity, and the result is statelessness, exclusion, and caste-like hierarchies. The Dominican Republic provides the clearest warning and probably the closest analogy today. In 2013, its constitutional court retroactively stripped citizenship from people, primarily Dominicans of Haitian descent, who had long been treated as citizens, reaching as far back as 1929. According to the brief, this rendered approximately 200,000 people stateless. What is especially important is that the consequences were not merely administrative. People lost access to birth certificates, education, lawful employment, voting rights, and even the ability to register the births of their children. The brief uses this example to show how facially neutral restrictions based on immigration status can function as racial exclusion, creating what is effectively a permanent underclass. India offers a second cautionary example. In Assam, the National Register of Citizens required millions of residents to prove their ancestry and legal status through documentation. The fauna registry excluded roughly 1.9 million people. The burden fell mostly on the poor, rural, and minority communities who lacked the paperwork necessary to prove lineage, despite having lived there for multiple generations. And the broader lesson is that once citizenship turns on documentary proof of ancestry, the system disproportionately harms the most vulnerable and creates prolonged legal uncertainty. Myanmar shows the most extreme consequence. Its citizenship laws created a tiered system tied to recognized ethnic groups, excluding the Ranjana from full citizenship. As the brief explains, that legal exclusion became the foundation for denial of education, employment, political rights, and ultimately mass displacement and ethnic cleansing. Taken together, these examples reinforce the brief's central constitutional point. When citizenship is made contingent on ancestry or political discretion, it risks producing stateless populations and entrenched systems of caste. That is precisely what the 14th Amendment was designed to prevent in the wake of Dred Scott v. Sanford and Reconstruction. Thank you.
Good morning, everyone. I'm going to briefly wrap us up and just talk a little bit about our overall reactions to being involved in this project and some of the work process that we went through. We all really enjoyed collaborating with each other. We, as you know, start from different sections when we start as 1Ls, and so we don't always have the opportunity to build relationships and work with some of our colleagues, and so this was a great opportunity to do that in a very consequential and important case. We also really enjoyed working with our colleagues at Harvard and kind of seeing how we operated differently, similarly, and learning from that experience of working across schools. Seeing our research in a Supreme Court filing was honestly a little bit surreal, and it's an opportunity that not a lot of law students get to do, and it's not even an opportunity that a lot of lawyers get to have. And so we were really blessed and excited about that chance to do it. This was also a really realistic experience for us of what the civil rights work that a lot of us came here to do will look like. We, for the most part, come to Howard University School of Law to be social engineers, and this is what that work is. It was difficult. There were a few long nights. There was some difficulty finding some of the right pages for the legislative history or whatever statute from Myanmar we were looking for, but ultimately we produced, I think, something that all of us are very proud of, that Professor Ifill is proud of, Professor Charles, and I hope you all enjoyed reading the brief, and we are hopeful for a favorable ruling. Thank you.
Good morning, everyone. I am Naquan Bush, a third-year law student here at Howard and one of Professor Ifill's seminar students, and I'm excited to welcome you to our first panel after the argument, Birthright Citizenship, the 14th Amendment, and the Supreme Court. In the wake of oral argument in Trump v. Barbara, this conversation will examine what we heard in the court, what may come next, and what this moment means for birthright citizenship and the future of the 14th Amendment. We are honored to be joined by an incredible group of speakers. Mark Joseph Stern, senior writer at Slate. Nana Gyamfi, executive director of Black Alliance for Just Immigration. And Madiba Dennie, deputy editor and senior contributor at Bells and Strikes. Balls and Strikes. Oh, Lord. The panel will be moderated by Sherrilyn Ifill, founding director of the 14th Amendment Center for Law and Democracy. Please join me in welcoming our panelists.
Weren't the students great? Yes. That's so awesome. And the brief that we filed is in, if you didn't get a swag bag, you can get one on the way out. There's bags on the table, and so you can see a copy of the brief. I am so excited to be in conversation with this group of people. I admit that putting this together, some of you have heard a lot about the argument already. And so I had to come up with a spicy group to give you a different kind of perspective than you might have heard. And these three are the spiciest. So I was in the courtroom. How many of you were there? Were you there at the argument? I was at the argument.
Just watching the C-SPAN.
Just watching C-SPAN.
Yeah, that's the same.
I try not to be in the same room as Samuel Alito, if possible.
Well, I was there. It was. I'll just say that the atmosphere was, very serious. It was packed. It was a very good argument. I thought that Cecilia Wang, who argued for the ACLU, was extraordinary. Was absolutely extraordinary. And what you couldn't see unless you were in the room was and I just keep saying this to her poise. She was doing, I've told the students exactly what you want to do in oral argument. She was in a conversation with the justices. She feared no question. She answered every question. I could feel her calculation. Is that a trap? It's coming from Alito. It probably is a trap, but she was just really incredible. And I just say I'll take a point of privilege to say that given the moment that we are in and all that we have heard, to have this extraordinarily brilliant Asian American woman, daughter of immigrants, wipe the floor with that argument was especially moving and important. Okay, so I'm going to start with the far side of the room with Madiba Dennie, and because the received wisdom is it's a win for the Barber plaintiffs, and is there anybody here who thinks that it's not going to be, when I say a win, I don't mean that in the deeply esoteric sense. I mean a numerical win for the Barber plaintiffs. Does everyone believe that? Okay, great. So we can start from that premise. And so I want to begin with just that part. Many of us were astonished, frankly, when this case first was taken to the Supreme Court in Trump versus Casa, that the court would take this case. So as I was listening to the argument sitting there, and I had the same impression that the Barber plaintiffs will numerically win this case, and probably in a rather lopsided way, what was all this for? Here we were in this packed room. I knew all the work that the lawyers had put into, all of the briefing and the arguments, and there was a moot that was held here at Howard. There was, you've heard my students talk about their amicus brief. We know what happened in Trump versus Casa and all the work that went into that. I looked at this packed courtroom. The president himself felt he had to come and take a peek. He didn't like what he saw, but he had to come and take a peek. So here we all were, right? All the security guards, all the stuff. What was that all about? Why were we here in that courtroom hearing this case?
We were there because the Supreme Court wanted to be there. It was deeply unnecessary for them to take up the case. They had so many opportunities to stop it from reaching that point. They could have left the injunctions in place in Trump v. Casa. They could have that could have
describe what you're talking about. The nationwide injunctions that had been issued by district courts.
Right. Fairly quickly after Trump issued his executive order purporting to override the 14th Amendment's guarantee of birthright citizenship, multiple district courts heard the case and said, this is very obviously illegal. There's no question about it. We're blocking this nationwide. And so, and Trump filed an emergency petition, emergency motion to the Supreme Court saying, you gotta lift this injunction. This is so important. I'm gonna be irreparably harmed if I can't violate the Constitution right now. And the court, they could have denied that, but they didn't. They heard his motion. It reached the Supreme Court. They had an oral argument, and the Supreme Court decided to lift those injunctions, modifying and like send them back, putting the burden back onto newborns and their parents and their representatives to file new lawsuits, having to go through a different obstacle course with doing class actions instead, saying, no, you're not allowed to do nationwide injunctions, actually. We are limiting the power that federal judges have to rein in the Trump administration. And something else that I found striking about the case, I'm like, even if they wanted to limit that power, they still could have said, you know, as a general rule, we have a problem with nationwide injunctions, but this particular nationwide injunction is still okay because it does not clear our existing standards for when you lift an injunction because of the irreparable harm at stake, you know, because of the balance of the interest. So they had all these options of things they could have done, and they chose not to take them. They chose to let people live in uncertainty and confusion and fear and danger and vulnerability for months and months and months and months until it reached the Supreme Court all over again, just to sit there and play in our faces and be like, oh, yeah, I guess we can just affirm the existing 120-something-year-old precedent because we have done this before. It is like literally the same arguments being made on both sides. And yeah, so it was deeply unnecessary. Yeah, and I think it's important to recognize that even though this looks like a win numerically, it's a win for the Trump administration that it even got to this point. It's a win for the white nationalist movement that they've normalized the idea of limiting birthright citizenship. It's a win for them that Justice Kavanaugh, during the oral argument, entertained the thought of, okay, so even if Trump can't do it, though, can Congress do it? Like, how could they go about altering birthright citizenship? So all of these are just huge shifts of the Overton window, and like, are there windows in hell? Because that's where this is right now.
I think the point is there are not windows in hell. So I don't want to leave this point for a second because I think it's actually super, super important. And Nana, I'm going to go to you to help us understand what Madiba was referring to about the effect on people of allowing this to go forward. Can you just say something more about that?
Yeah, absolutely. First of all, so happy to be here. Thank you so much for the invitation and for this panel. So as you were talking, and actually as the students were talking, I was thinking, you know, there's that famous quote that so many of us live by, Charles Houston talking about an attorney's either a parasite or a social engineer. What happens when the parasites are social engineers?
Spicy, I told you.
Because that's literally is what we were there for. Is because the parasites want to be social engineers. This is part of an arc of stripping away rights from immigrants, and in particular, immigrants of color, Black immigrants. As Baji represents, we fight for the rights of Black migrants and African Americans.
And you all filed an amicus brief as well in the case.
Absolutely did, because someone had to bring Black immigrants into the fray because this impacts us, right? And so it's important for us to understand that the arc is already happening. This effort on behalf of the regime to pull away rights from people who had status. So they would like to have this conversation about undocumented people. They're trying to make everybody undocumented. And this attack on birthright citizenship, from our perspective, is the ultimate attack on, or the ultimate effort to make undocumented people out of Black people in particular, and people of color, because it is based upon Black people in this country being able to now be defined as citizens when in fact this country was not having that definition. And so when we look at the impact on Black migrants, people like my father who came here, my parents came here, my mother passed long ago, peace be unto her. My parents came here as students. went to Berkeley, and I was born here when my parents were on a student visa. My sister, who was just here yesterday, another sister member of the Supreme Court Bar, was born here when my parents were students. And what this would do if it was, if we were in this time period, would be to take it back. My 85-year-old father called terrified from Ghana, saying, these people, if they are taking it away, now if they try to take it away, the next step is gonna be that they're gonna take it away from you, that they're gonna take it away from people who were born way before this executive order and decide that they're not citizens as well. And that was a fear that rippled through a community of Black immigrants who already had hundreds of thousands of people who had been stripped of TPS, the temporary protective status, already had hundreds of thousands of people who had been taken out of humanitarian parole programs, already have hundreds and thousands of people who are refugees now that this administration is talking about recertifying, right? Making you go back, even though you've been in this country for 20 years, to prove that the Sudan is still dangerous for you, right? Already talking about denaturalizing to a point that they have a whole section of, that's dedicated just to denaturalizing people, of which Black Muslims are disproportionately impacted, from Senegal, Nigeria, and Somalia, of course, right? And so we see this arc in this effort to define who is worthy, who is able, who is allegiant, who is good, and making that the basis of citizenship, pushing aside the idea of guarantee. And of course, if we look at who is worthy, who is allegiant, and who is good, there are people in the White House right now in their departments who are children of citizens, immigrants, who should be gone. Because there ain't no more unworthy, criminal, disloyal folks than the folks that we see right now, parasites trying to be social engineers.
Well, now, you said something that just absolutely blew my mind, and I'm going to actually raise it with the voting rights panel. You said they're trying to make everybody undocumented, and that really got me thinking about the SAVE Act and all of this. Yeah, wow. Okay, I'm going to come back to that. Also want to point out that Justice Sotomayor raised that issue, right? And the Solicitor General said, "Oh, no, this is just prospective. The EO is just, looks to the future." And she said, "But a subsequent president," she said, "this president," when he was sitting in the room, she said, "this president or a subsequent president could now try to move it back, right, to people who have already been here and try to make it retroactive." So she clearly recognized that danger as well. Mark, this is the last round on why they did this, because I have my own theory about why they did it this way, and my theory leaves me very troubled. But I want to hear what you think. Why did this happen?
Well, so the question in this case is, can Supreme Court justices read? Can they take out their pocket constitutions that they wave around at events, right, and turn to the 14th Amendment and read the first sentence, right? That is it. And then if they can, then of course Trump loses. And if they can't, then we're all in a lot of trouble. It seems like they can. Maybe at least 7 of them can, which is like as good a count as you can expect these days. And so the court will almost certainly rule in favor of birthright citizenship and probably affirm it under the 14th Amendment and not leave open the door, as Madiba was saying, for Congress to repeal it or roll it back in the future, which is a good thing. But as I think we all agree, it's outrageous that the case got to this point, that we're at a stage that the Supreme Court is seriously considering whether the Constitution means what it says. And there are ambiguous provisions of the Constitution. This isn't one of them. This has been settled law for a century and a half. The Supreme Court dealt with this in 1898, and a bunch of racist justices said, even we, the racist justices of the Supreme Court that decided Plessy versus Ferguson, have to acknowledge that, of course, the 14th Amendment guarantees birthright citizenship, and now it's back, and the same question is being asked. And to me, my fear fear is that the Supreme Court is going to use this decision to try to launder its reputation and try to hold itself out as less partisan and more independent, and to try to show the country that it really is not entirely beholden to Donald Trump, and that it is willing to shoot down parts of Trump's agenda if they don't align with the Constitution. Now, look, I'll take the deal, right? It's better for the Supreme Court to strike down this executive order and get this reputational boost that it doesn't deserve than the opposite. But it really will not deserve the reputational boost that we'll see. I mean, you can already project the headlines. Front of the New York Times, Supreme Court declares independence from Trump. Supreme Court overwhelmingly reaffirms basic constitutional guarantees. They're going to get a tongue bath in the mainstream press. And they're really not going to deserve it because, again, this is probably the simplest case you could imagine going to the Supreme Court, and it still probably won't be unanimous at that.
I want to just tack on a little bit with that. Two things. One, I just say how it probably won't be unanimous, and I think that's important to note that like anything. So first of all, they shouldn't have heard it, but second, if they are hearing it, it should be unanimous, and anything other than unanimous is a failure. It's absurd. It's completely damning for the court as an institution. And I was also just thinking about the unearned sort of praise. I just wanted to flag that we're already seeing that. And I felt it in my bones. I knew it was coming as soon as John Roberts said that line when he was like, "Oh, it's a new day with the same Constitution." I was like, "Ugh."
Yeah.
I was like, that's the money line. He was practicing that in the mirror, and like he knows that folks are gonna like run with this and be like, like John Roberts here declares his independence, like upholds the Constitution, and it's doing the literal bare minimum. Yeah. Like it's something that even the Plessy court could do.
And it gives them a lot of political capital that they can then spend down supporting other horrific aspects of Donald Trump's agenda that they happen to agree with. Right.
Say,
or their own agenda, CEG, Louisiana versus Calais, which we'll talk about in the next panel.
Right. Exactly.
So, okay, I get that. I see that, but I'm not sure they could have seen, well, maybe they could have. So that's a theory, and I think that's a live theory and absolutely what will happen. Like, I think that's how it will be used. My theory is that they knew it was terrible, but it came in such an attractive package. And the package was the obsession with nationwide injunctions. It came in this package of district courts, and it was multiple district courts, having issued nationwide injunctions saying that Trump's executive order could not be implemented because it flagrantly and plainly violates the first sentence of the 14th Amendment, which guarantees birthright citizenship. And by the way, in your swag bag is your pocket Reconstruction amendments. Yeah. So look, he's holding it up. Hold it up. There it is. There it is. I call them your freedom papers. And so you want to carry these in your purse, keep it in your glove compartment. You get pulled over, you just say, "Officer, no, don't do that." But do carry it and share it. I think because the case came in the posture of giving them an opportunity to finally and at long last strike down nationwide injunctions against a Republican, issued against a Republican president, because they had the chance when Biden was president and they didn't do it. But it came in such an attractive package, they had to take it. Remember, they didn't even deal with the merits at all. All they were focused on was the nationwide injunction piece, and it was too rich an opportunity for them to pass up. So they took it. They got what they wanted. They struck down nationwide injunctions. They sent it back with some class action thing that they clearly didn't care about. And now they had to continue to play this out because the case was still, people actually refiled the case. They did the class action thing. It came back. And now they had to keep it going. And so that's what I was feeling, that this was all just like a Potemkin argument, just a play to finish out a process that was actually started because it came in the package of something they wanted to accomplish that was on their wish list, which is about nationwide injunctions. And the reason why that bothers me almost more than the diabolical reasons that you all suggested is because it shows a court without discipline. A court so lacking in discipline, so bent on its agenda that it was willing to throw millions of people into a state of uncertainty and chaos about their status as Americans in this country in order to get at something that is on the conservative wish list, the nationwide agenda issue. What do you think?
Yeah, that makes good sense to me.
Yeah.
Because thinking about Trump 1 and how did we beat Trump 1 back? Particularly, I'm thinking about issues of immigration, but also issues relating to voting rights and other rights. We got nationwide injunctions. We were able to talk as bars with one another, right? As lawyers with one another to say, hey, okay, you're gonna do this thing. Okay, we're gonna do it on this basis. We're gonna do it on this basis and do what we're supposed to do because we're not the parasites. We are the social engineers, right? To think about how we take this, the promise of justice, equality, et cetera, that the 14th Amendment first talks about in terms of the Constitution, and to move that forward. And so part of the moves that they've been making have been, I would totally agree with you, to try to stop the effectiveness of the law, the effectiveness of the courtroom, and what we were able to do in the courtroom to slow us down, to throw wrenches in our game. Now, we still moved because that's what we're here to do. We weren't going to be like, oh, and can I go back to bed? Like that wasn't what we were going to do. And luckily, so many of us were prepared for the fact that we were going to have to fight. And thank goodness for the attorneys that were ready for that. But I agree with you that to me is part of the parasites being social engineers, is figuring out how do they chip at some of the, I'm not going to say holes, but yeah, exactly. How do they chip at some of those
I'm
holes?
not sure that if it had not come in that posture, that they might not have played it out the way we think they should have played it out, that this was obvious and ridiculous. What do you think?
Well, just to contextualize.
You look skeptical. You look skeptical.
Well, just to contextualize for folks who aren't familiar with this background. So for 4 years under the Biden administration, district courts were issuing nationwide injunctions left and right, prohibiting the Biden administration from doing anything that it tried to do. Within a few days, there would be a nationwide injunction. The Biden Justice Department pleaded with the Supreme Court for 4 years to do something about these nationwide injunctions, kept going back to the Supreme Court saying, please roll them back, get rid of them, do something to diminish these nationwide injunctions because they're being grievously abused and the president can't govern because of them. And the Supreme Court refused. For 4 years under Biden, the Supreme Court refused to even consider the issue of nationwide injunctions. And then within 6 months of Donald Trump returning to office, the Supreme Court abolished nationwide injunctions. I think that timeline speaks for itself, and I think that aspect of your theory is absolutely correct. I'm not sure about the court choosing Trump v. Casa as the case to do it, as the vehicle to do it. I think maybe that was more, frankly, diabolically clever lawyering on the part of Trump's Justice Department, right? I think that Trump's Justice Department came in gunning for bear, wanting to get rid of nationwide injunctions, and decided that this was going to be the case to do it, and that they were going to show the justices that, this is being abused and we're being stopped all around the country. And then kind of, I don't know, to me, it was almost like a humiliation ritual. Give the justices a case where the constitutional issue is super clear, but still tell them, no, you need to use this one to get rid of nationwide injunctions. And they did it, right? All 6 of them lined up. All 6 of the Republican appointed justices did their role in the humiliation ritual and took a case that should have been a one sentence yes, the 14th Amendment means what it says, and instead agreed with the Trump Justice Department. That's right. Nationwide injunctions, very serious problem. Let's get rid of them.
I think I hesitate a little bit on the part about them being humiliated as opposed to being willingly complicit, because I think that we have seen other cases where they make random exceptions, where they have a random carve out and say, Trump can fire anybody he wants, but don't touch the Fed because of reasons. Right. So I think that if they weren't bad actors, they could have done some, I guess if they weren't as bad actors, because they are worse actors, they could have done something similar in the nationwide injunctions case to say that, nationwide injunctions were stopping them, except for this one, because this, we are creating this impossibly high threshold for nationwide injunctions that no one can meet except for this one. I feel like that's a thing they could have easily done to, preserve the 14th Amendment, like without sending everybody into, chaos and fear, but still getting rid of all the other nationwide injunctions, and they didn't take that path.
Because this was the textbook example of when a district court should have the power to issue a
Exactly.
nationwide injunction,
Right.
right?
Yeah.
Because it would depend on what state you were born in, whether you got citizenship, if you can't have a nationwide injunction, which would be insane.
That's right. I mean, I don't disagree with you. I do think that, and I raise this just because I think, for students, it's just important to understand how the court works, and that it's not inevitable that these cases, are argued and that they should be, heard by the court. I think we have to remember that it takes 4 to grant cert. Right. And so I do think that I want to return again to the discipline. I think that, we think about winning a case, we're talking about 5, right? And often we're talking about 6, but to have a case heard is 4. And I think that there are 4, apparently, justices who are undisciplined enough, who are so loaded for bear, who are so aggressively pursuing their agenda. And I think it's important to say also their agenda. I'm not willing to concede that this is like the Trump agenda. And the reason why I say this is because of the next panel's discussion about Louisiana versus Calais, in which the Supreme Court itself decided that, this case should be turned into a question about whether you can ever remedy racial gerrymandering. They have their own agenda, and I think this nationwide injunction piece was part of that. And I think we should be conscious of and be looking out for the reality that there's a lot of lack of discipline. And we see this in cases where every justice has to write an opinion. Like you won, you're in the majority. Do we need like a million different opinions? I think we're going to see a Kavanaugh concurrence talking about the power of Congress, to maybe do this. Like, I just think there is a kind of, I don't know how else to describe it, but I find it deeply disturbing. I mean, it speaks to John Roberts' leadership as chief, that he is not able to impose a measure of discipline, but it also speaks to the justices themselves and the way in which they use their power in ways that are very destabilizing. Do you know what I mean? Even that's beyond just the decision.
Isn't the abuse of the shadow docket the ultimate example of this
Right,
dynamic, right? They
absolutely.
can't even wait to hear a case.
Right.
They're just gonna vote over text message or something to give Donald Trump a win and then issue an opinion in the middle of the night overturning 100 years of precedent. That's how undisciplined they are. No previous court has ever acted as
I think
recklessly.
that's part of it. I think it's its own issue that I just don't hear enough about. It's that it's not just decisions that come, and I want to emphasize this because I'm sure if my dean was here, he would want me to emphasize this, that the work of the 14th Amendment Center and this law school is nonpartisan. Let me say it again. The work of the 14th Amendment and this law school is nonpartisan. We do, however, believe in justice. We believe in democracy. We believe in the rule of law. We absolutely believe in the rules of litigation and the integrity of courts and how they should behave that allow us to be able to litigate effectively in those courts. And so I just think, so I wanted to say that. Speakers can, my guests can say whatever they want. I just want to be clear about that. But I also just want to be clear about the fact that there's something more going on that is not, like, almost, we make it easier when we make it like it's just about ideology. And the reason I'm raising this is because I want us to turn to talk a little bit about the court itself and what we might want in the future. Because there are problems with the current court, and not all of them are about ideology. And I think we have to think a little bit structurally about how we would get a court that would allow those of us who are lawyers, who want to litigate, who are fully prepared to submit to the system, right, that we have agreed to be a part of. We're lawyers. We signed up for it. We took the oath, right? We were sitting in the court. I had on black. I follow the rules, right? And we should be allowed to work in that system. But it's very difficult to work in a system, right, that's not just about whether the judges have an ideology that's different than mine. It's about whether or not they're even going to follow the rules that they have imposed. Do you follow what I'm saying? Madiba, what do you
Yeah, I mean, I think that to there's a certain extent to which their ideology influenced the rule breaking. like they are deviating from the rules because they want to, further their agenda, their like far right goals. I think there was a really striking to me example a couple weeks ago that hasn't gotten a ton of attention yet, in like a New York redistricting case, the Malliotakis case, where the Supreme Court reached out again, breaking its own rules, reached out to overzealously, aggressively, undisciplined, to block an order from a state trial court. It was a state trial court in New York said that a redistricting map violated the New York State Constitution because it discriminated against Black and Latino voters, and ordered the state's redistricting commission to draw a new map. And the Supreme Court responded to an emergency petition and blocked that order. This New York's highest court hadn't heard the case yet or weighed in. The New York Redistricting Commission hadn't even drawn the new map yet.
And can you just slow down and explain the significance of the fact that the New York Supreme Court, the highest court of the state, had not ruled yet for our students, just so we're clear about what the process is supposed to be?
Yeah, so this is, the reason why I thought of this, because you're talking about the rules that courts are supposed to follow, the rules that, everyone is supposed to be playing by. And one of those rules is that, Supreme Court has limited jurisdiction. It hears appeals from, intermediate, from your circuit appeals courts, and they can weigh in after on a state court issue if it has reached the state's highest court. They don't just jump in at the lowest level because they don't like what a trial court did. So all sorts of stuff could have happened. There would have been more litigation in the trial court, would have gone to the state intermediate court, the state highest court. They short-circuited all of that because a state trial court said, be less racist when you're drawing your redistricting maps. And that's horrifying to me. I think that's, deeply troubling both for the Federal Voting Rights Act and for, states attempting their own statewide voting rights acts. And I think it really sort of proves the point of how when something they want to do is at stake, they're whether it's purely ideological or just on their own checklist, they will toss the rules out the window, abandon what federal law says, what establishes their jurisdiction. They couldn't care less. They're just acting recklessly and with impunity, reaching to do whatever they want to do.
Yeah, I just want to make sure that we flag that, as an independent democracy issue, because we tend to talk about the issues of challenge that we're facing in our democracy and purely in the terms of the political branches, the so-called political branches of government, the president and Congress. And we don't talk about what happens when the highest court is running roughshod over the rules, right? Whatever their ideological view, the rules that are supposed to make the playing of the game fair.
And
right?
predictable.
And predictable, right? And for us as litigators, we're counting on predictability, right? When you're deciding whether you're going to file a case, where you're going to file a case, whether you would even take that case to the Supreme Court, all of that is based on some measure of predictability from you knowing the rules. And if that's off, I'm not sure how we, you're talking about the role of lawyers, how we continue to navigate in that process. And this was an example to me of that, where I feel like that, and absolutely the New York case I'm not sure why it didn't get as much attention as it should have. It was pretty mind-blowing. Yeah. It's a very elementary thing that every lawyer knows, that right, that it has to be the state's highest court before it goes to the Supreme Court. Yeah. So it was, and then the way Justice Alito described it was just untrue.
Mm-hmm. Mm-hmm. Well, the untrue part, I think some of this people are just normalizing at this point. But thinking about what you're saying, both of you, and the notion of not being able to know what to do, I think there's two pieces to that. I think one piece is people around the world depend on the United States and what happens with this legal system as an example of how the legal system works to further and maintain democracy, right? So if we take this same thing that is happening, and if we now pick it up and put it into a country that has banana trees, Everyone is like, what is going on? That country is horrible. It's a this type of country. I won't use the word. It's a who and a what, because these Negroes don't know how to act. You know, they don't know how to have a court system that's proper. They don't know how to do this and that, you know? And you have people that come to this country from countries all over the world who are coming to this country with the notion that they're coming someplace where there is going to be a system, in terms of a legal system, where they can have some predictable justice. It is one of the indicators of whether you are a democracy or not, right? When they have those lists of countries and the United States keeps going down and down and down in terms of being a democracy, the legal system and this unpredictability is a piece of that. And I think that is purposeful. And I think it's ideological, maybe not in a political sense, but if we look at the people on the court, the justices that are pushing this issue the most, we can find in opinions that they've done before, if they ever did an opinion before, right, wrote it before. We can find in conversations that they've had, because they were all in different places, talking to real life people. They weren't always behind, you know, the bench and wearing those robes, that this notion that the Supreme Court should be able to go in and act as like a gunslinger, right, for things that they don't like, is something that is normal. That is what they actually think this court should be able to do as it's part of the breaking up of this system. The second piece for me, though, is wherever there's a breaking up, wherever there is sort of instability, it does give us the opportunity to think to ourselves, well, what could we do? Right? It's like you shake stuff up and you think that you're just causing me to fall. I live in LA, right? So it's like you have an earthquake and, you know, you're shaking stuff up and it is scary on the one hand. And on the other hand, you start to think about, okay, what can I do to make sure that I'm more stable? What can I do to make sure that we are more stable in this system? What do we look at to make sure that we're plastering? Because there are clear cracks that people have been ignoring or doing a wink and a nod, you know? So they get up and they say, I will follow the Constitution. Oh my God, I will never overturn precedent. Oh my goodness. And we're watching it and we're saying, you absolutely will do all of those things. But we just let the process go through, right? We're not stopping it. So it's like, it's a clear gap. It's a clear problem. How do we finally decide to take it seriously? And then think, once we do that, what did James Baldwin teach us? If you want, you have to face the challenge, right, in order to address it. And I think we have to face the challenge that this system that people thought was inherently a system that was stable, that was good, that was predictable, and that was unshakable has been shaken like a snow globe.
Can I just
Thank
add?
you so much for that. Go ahead, Mark.
Yeah, a really important issue that brought to mind is that this is a warning to Supreme Court reformers, I think, because
That's why I'm raising it, Mark.
yeah,
Yes.
that there are a lot of proponents of Supreme Court reforms who say basically Congress should enact these statutes that would rein in a Supreme Court that's out of control, that would, you know, limit its jurisdiction. Congress could say the Supreme Court can't hear these kind of cases. Congress could try to impose statutory term limits. Congress could roll back the shadow docket, require written opinions in cases, put time limits on, you know, certain appeals, whatever. All of this
And
stuff
they could.
that I think they could and should. But guess what Congress already did? Congress already told the Supreme Court, you can't review state court decisions until the highest court of that state has acted. And the Supreme Court said, don't care. We're just gonna do it anyway. And the Supreme Court didn't even bother to explain itself. And when Alito tried to explain, he had to lie. He had to misrepresent the facts in order to justify what the court did, because it broke the law. Congress tried to put limits on the Supreme Court's authority. The Supreme Court ignored them and broke the law in service of maintaining a very, very white congressional district that will now certainly go for Republicans. Just a coincidence that that's the outcome of that case, by the way. You know, no connection there. And so I think that when this window that you're talking about, Nana, opens, when the earthquake happens, the window opens for change, I think reformers need to think very carefully about what changes are truly going to be durable. if they're trying to rein in the Supreme Court's power and impose some democratic accountability on the Supreme Court, and which are just going to be bulldozed over by the justices who have already shown that they really do not respect restraints on their authority and insist on being the final deciders of every single issue, and just don't believe that the other branches have any legitimate say in how they do their business.
I want to add to that because I agree in that I think, we definitely need to think about what can be durable structural changes. I also think it's important to not just sort of assume that they will be durable. I think you had pointed out, Nana, about folks just thought this was like inherently good and that like this would just work like it's supposed to. And so I'm thinking, yes, we need to make these structural changes, but we also need to remember that structures work to the extent people decide to follow them or not. And so it's both a matter of the structural change, but also people changes, culture changes, and like maintaining pressure on these institutions, because we can't, recognizing that it is going to be a sort of constant process. We can't say, okay, we've made this change, so we fixed it. We can't leave these people and these institutions to their own devices. We have to stay on our asses, basically. Is what I'm saying.
This is the the takeaway, right? So, and part of why this is important to me is, I'm writing about this, but also because part of what we have to do as citizens of the new democracy that we're trying to create is create a new ethic of how we engage with these structures, and to understand that nothing is set forever. This is an iterative process.
Right.
It's not like you refound and then you wait another 60 years and then you refound. That's not it. It's what we're doing in the in-between is not working. And part of what we're doing is conceding space to just allow things to play itself out. And we're not thinking constantly about how can we make it better? How can we make it better? How can we make it better? And particularly with the Supreme Court, which the part I'm writing about now is how, this is basically the Brown boost that the Supreme Court got,
Right.
We had a Supreme Court that for 25 years actually expanded access to democracy and justice. And that's only 25 years in the entire history of the Supreme Court. And they have been living on the fumes of that. It made everyone else withdraw. It made Congress step back. It made the public step back. It made the press step back. It made us all believe that the court was the answer and that the Supreme Court is this arbiter of justice when that is contrary to its history over the course of time. And so this hands-off approach is part of how we have ended up, I think, with a court that operates in this way with a certain kind of impunity. And so
riding the Warren Court's coattails.
For sure. The very Warren Court that they criticize.
While they criticize it, exactly. I'm they're undoing all of those gains, but benefiting from that reputation.
Yes, exactly.
Because of all of the, the good work that they did. So people thought, I can trust the courts.
That's
the courts
exactly
are here
right.
to serve us. They're here to uphold the law and protect people. And they use that, that good reputation while just doing untold harm.
So they're living in the brown bump, and we have to end it. So, okay, we're running out of time. We're out of time. And so I want to do a quick lightning round, and I'm going to ask you two questions. The first question is going to make you angry, but I'm going to ask it because one of the things I think is important is for us to not have a failure of imagination. Okay, because we've seen a lot of crazy things we thought could never happen. So now I'm like, what's the craziest thing that could happen? Okay, so here are the two questions. Number one, what's going to be your statement after the birthright citizenship decision comes out? Let's say 7-2. Let's say 7-2. What are you going to say? Because you've already said what you think the narrative will be out there that you don't like. So what's the narrative you're going to issue? And you got to do this really quick, and there's got to be discipline. The second thing is, what if the Barber plaintiffs lose? And it's a 5-4 decision. And the Supreme Court says the president does have the right, that's subject to the jurisdiction thereof, does leave this space for ensuring that the children of non-citizen parents can be denied birthright citizenship. Now, I'm going to start at the far end with Madiba. You're going to do it in a lightning type way. You're going to say your statement, and then you're going to say, what would you do? What should be done if the Supreme Court did that?
I'm calling for impeachment. Oh, yes. I mean, even if it's 7-2, I'm calling to impeach the 2. I'm saying that I'm saying that there is no world in which you can be qualified to be a Supreme Court justice and reach that ruling, because it is so fundamentally at odds with the 14th Amendment, with the text, the purpose, the history, the goals, just like all of it, the very ethos of multiracial democracy. I'm saying you clearly cannot be trusted. Definitely at least those 2. But I'm saying, and so I guess regardless of whether it's 7-2 or 5-4, I'm going to say anything other than a unanimous ruling is a referendum on the Supreme Court, saying that it is damning, because that shows that at least some of the court is willing to somehow say that a post-Civil War amendment allows the president to unilaterally reimpose a pre-Civil War legal order where there's a hereditary racialized underclass where disadvantaged.
Have you written this already? Because this sounds.
It's just been on my mind. Saying, we cannot live. The Constitution does not legitimately authorize such a world where the president can arbitrarily take citizenship away from people at will. That is, and last time the Supreme Court said something like that could happen, we had a civil war. So I would rather us not have a civil war. I would rather not come to that sort of bloodshed. And so I think anything other than a unanimous ruling, I would say, mandates court reform and impeachment.
That's a statement.
But how will you react if they win?
How will I react if
If the plaintiffs win? That was Sherrilyn's first question,
Yeah,
right?
the first question was, what's your statement if they win? But she said anything less than a unanimous. I think that kind of covered it, right?
I like
because
that. I
that
like
was
that.
good. Yeah.
Yeah, okay.
And if it's unanimous, then say,
Yeah.
congrats on your literacy.
I think that's right. I think that no matter what, a win for the Barbara plaintiffs, like all we can really say is Supreme Court does the bare minimum necessary.
Turns out Brett Kavanaugh can read.
Yeah, to show that they have like 6th grade literacy
No, because
level.
he's going to write that concurrence.
Yeah, no, I agree. I mean, I think that will probably be my take. I think it will be interesting to see how much annoyance the majority might express with the Trump administration for putting them in that position, although I think that would be kind of kayfabe, because I think that really they'll be glad to say, oh, look, we're independent from Trump again. But I'm not going to give them undue credit for reaching the right result in an extraordinarily obvious case, and I think I'm going to very quickly be pushing back on that overwhelming narrative in the media. If the Trump administration wins, I think that my view will be court expansion needs to be the #1 issue on Democrats' agenda the next time they retake power. I think impeachment is also an appropriate response, but removal requires 2/3 vote in the Senate. I don't think that Republicans will ever vote to remove a Supreme Court justice.
So we could at least minimize the impact of that one by adding some more.
Yes.
Well,
Who is on their team?
But let me just push back for a second, Mark. I just would say that, I'm a real big proponent that we should say the things that should happen, whether, regardless of whatever the political count is. Do you know what I'm saying? So I think, that's just my view. Like if you, and this is, I'm not even talking about the Supreme Court, but if you think that impeachment is appropriate, you should say that, because that's the constitutional provision for removal. And so even regardless of the count, and who knows what happens with the Senate? Who knows what happens with the Senate?
I suppose that's true, although if a justice is impeached and removed right now, then Donald Trump just gets to replace him with like Justice Fascist McHitler, who's 32 years old.
Fascist McHitler's already on there.
Yeah. I do have some skepticism about that more broadly.
I'm not disagreeing with your real politique.
Yeah.
I think you're right. I'm just saying, I guess
there's value in saying the words.
Yeah, and also
for sure.
I feel lawyerly about this.
Yeah.
I feel like, it's not as though the first founders never thought you might need to remove these people, right? Like, even to the extent that we behave as though you can't, they actually included a provision. It's right there.
Right.
And we shouldn't just ignore it because of the political count. We should say what the law is and says, right? And allows, and we should lift up what the tools are to try to right the ship. even if we don't think we could politically activate those tools at this moment.
Sure. The
you know what I mean?
Constitution allows them to serve for
Yes.
good behavior.
Yes.
And it actually does
You
not
know?
say that removal would require a 2/3 vote. And there are some scholars who think that it could be done through a majority vote because it does not tie Supreme Court impeachment to presidential impeachment that way. It's a theory that's out there. So I agree with the lawyerly take on that. But going back to realpolitik, I mean, I just think that, you know, there's sort of one lever that Democrats would be able to pull at that point, and it would be the expansion lever. And there was some movement toward this under Biden. The Supreme Court sort of played its cards very cleverly, I think kept a lot of that at bay. President Biden wasn't willing to go there, but I think it needs to become a litmus test for future politicians and current politicians in the Democratic Party. Like, this would be a decision so catastrophically wrong and racist and dangerous that it would genuinely set this nation on the path to disunion, I think. You would have blue states insisting on recognizing the citizenship of children and red states refusing to recognize, and the federal government weighing in on behalf of those red states. That sounds like the Dred Scott regime.
It really does. It really does. And I thought it was interesting. You remember during the argument, Clarence Thomas raised the issue of
Yes.
state citizen, because the language of the Birthright Citizenship Clause is that any person born or naturalized in the United States and subject to the jurisdiction thereof is a citizen of the United States and of the state in which they reside.
Yeah.
And he raised, I didn't know where he was going with raising that, which was like weird. That's why I keep raising, should we maybe imagine the unimaginable? Because there were just some creepy questions that I couldn't really figure out from a number of the justices where I was like, what are they talking about? So I don't know. I just think, but your scenario is absolutely right.
I think that's where we go,
Yeah.
toward disunion. And I maybe the federal government is intervening one way during the Trump presidency, but under the AOC presidency in 2029, it's the other way. And it's just like Lincoln.
But that's not citizenship. Like
Right.
if it's just like, woo,
Yeah, no, it's not at all. And that is a terrifying vision that could really only be remedied by insisting that the decider in our system right now, which is the Supreme Court, be sort of rebalanced so that it can get at least the most basic questions correct.
I also just want to tack on super fast that in addition to making court expansion a litmus test for Democratic elected officials, I think we should also have some litmus tests for judicial nominees, including things like, do you think the 14th Amendment means what it says? Just like what is your method of constitutional interpretation? Like, are you rejecting the kinds of things?
They ask that.
Yeah.
It's that question's not working. I have some questions in store, and I'm keeping it in my pocket. But anyway, I'm sorry. Let's go on to Nana, and then we'll close.
So I'll say, standing as Baji does at that intersection of Black liberation and migrant rights, I would say that if there is a decision, whether it's unanimous or, that's in favor, where it's unanimous, or whether it's split, or 7-5, whatever, 7-2, excuse me, et cetera, I'm dreaming about that already. I'm thinking about that already. The headline for a Baji statement would be, Black people, comma, you in danger, girl. That would be the headline. Because basically, Black people, we be in danger. Because just the fact that they've broached this, going back to the social engineer, just the fact that they talked about worthiness. They talked about allegiance and loyalty. And they talked about criminality without using the word criminality, right? This idea that people are coming here and having kids so they can do some version of the welfare queen. The fact that it tracks the mother, right? So it's like the undocumented mother. And just as enslavement tracked through the mother, right? There are pieces of this that are speaking to this Dred Scott Union, that are speaking to it even if the case is won, right? And so I think Black people, you in danger, girl, is the statement. I think if we lose, or if there's a loss, that of course it's even more exacerbated. Either way, from the perspective of an organization whose interest is power building, we're gonna have to get people into this. Because I think that has also been part of the issue. This has been birthright citizenship and the attack. They've been talking about this for a long time. People didn't believe it could ever happen. And so the kind of movements that we need people to engage in mass levels have not occurred. We didn't have thousands of people at the Supreme Court standing outside, right, in ways that we should have, right, based upon what was at stake in that space. And so for us, that's the work that has to happen, right? It has to happen regardless of of how the decision comes out, regardless of the words that are used, because they have shot that, the shot across the bow to let us know, Black people, you're in danger, girl.
Ooh, ooh. You are so right. It should have been covered with people. That is so true. I found a 2010 piece that I wrote about birthright citizenship. This is when Lindsey Graham was saying, and we're going to deal with birthright citizenship. And I wrote this whole long thing about how then Wong Kim Ark, I did the whole thing. That was 2010. Yeah. We can remember the birther controversy with Trump demanding the birth certificate of President Obama. And I did believe that it was, it couldn't happen. I regularly apologize to my friend, the great historian Martha Jones, who, she used to say that, well, birthright citizenship is a guarantee, but that doesn't mean it's a guarantee. And I used to be just so furious. And I would just say, Martha, I don't understand why you say that. You're giving power to the other side by pretending that this is something optional. Like that's not what we say about the First Amendment. And she said, and you'll like this, Nana, she said, I agree with you, but I am not, this is about real people. And real people have decisions to make about how they're gonna move and care and live in this country. And I'm not gonna pretend to real people that the impossible is possible. And so I regularly, like now when I see her, I'm like, I'm sorry, because she was right. And so I agree with you, and I'm really glad that you said that. I too was surprised. I thought there would be a greater showing. I think it's that people but at that point before the argument, people didn't even know whether it was gonna be one way or another, and they just didn't show up for something so important. So I'm really glad that you added that perspective. I hope that you appreciate how exciting and powerful this conversation was with these amazing individuals. See? You hadn't heard this before. You didn't hear any of this before in the debriefs about the argument. I thank you all so, so much, and I think we have a set of students who are going to introduce our next panel. Thank you all. Please stay.